All right, welcome back to the Deep Dive. Today we're taking a look at a pretty significant Supreme Court case, Obduskey v. McCarthy and Holthus LLP.
Sounds intimidating.
Yeah, it's a mouthful. But this deep dive, we're going to try and break it down. Basically, the big question here is whether a law firm, when they're handling a non-judicial foreclosure, are they considered a debt collector under the FDCPA?
Ah, the FDCPA, the Fair Debt Collection Practices Act. That's a big one for a lot of folks out there.
It really is. And this case has some pretty big implications, not just for the legal world, but for homeowners too, especially if they're facing foreclosure, and for the companies involved in that whole process. So let's dive in, shall we?
Sounds good to me.
So to kick things off, can you give us the TLDR on this ruling? What did the Supreme Court decide?
Well, basically the court held that, generally speaking, businesses that are mainly dealing with these non-judicial foreclosures, they're not considered debt collectors under the FDCPA.
Okay, so not debt collectors, but I'm guessing there's a but coming?
You got it. There's one pretty specific exception. It all comes down to this rule against someone taking possession of a property when they don't actually have the legal right or even the intention to do so. That's laid out in section 1692(6) of the FDCPA.
Okay, so that's the line in the sand. They're not debt collectors in this context, but they can't just go around taking people's homes without following the rules.
Exactly.
So to really understand how the court arrived at this decision, I think we need to rewind a bit, right?
Yeah.
What was the background of this Obduskey case? What happened that brought this whole issue to the forefront?
All right. Well, we have Dennis Obduskey. He owned a home in Colorado. Back in 2009, he ended up defaulting on his mortgage.
And that's never a good situation to be in.
No, it's not. So Wells Fargo Bank, they hired this law firm, McCarthy Holthus LLP, to deal with the whole non-judicial foreclosure.
Okay, so far, so unfortunate, kind of typical, right?
Yeah, pretty standard procedure, at least up to this point.
So what happened next?
Well, McCarthy and Holthus, they started sending Mr. Obduskey letters about the whole foreclosure process. Kind of the standard communications in these situations.
Okay, makes sense. They've got to keep them in the loop. But this is where things start to get a bit more, interesting.
Right, because Mr. Obduskey, he responds to these letters, but he does it in a very specific way. He invokes a part of the FDCPA, section 1692GB.
Hold on. I need a quick layman's terms translation here. What does that section actually mean?
Essentially, it's the part of the law that says if someone claims they don't actually owe the debt or they dispute it for whatever reason, the debt collector has to stop trying to collect right then and there, and they have to actually verify that the debt is legit.
So basically, Obduskey's saying, hold on a minute. Prove that I actually owe this money before you come after my house.
Exactly.
So what did McCarthy and Holthus do? Did they stop and verify?
Well, that's the thing. They didn't. Instead, they went ahead and continued with the non-judicial foreclosure process.
And that, I'm assuming, is what led to the lawsuit.
You got it. Mr. Obduskey filed a lawsuit arguing that McCarthy and Holthus, by not following that whole verification procedure, they had actually violated the FDCPA.
Okay, so now we've got a legal battle on our hands.
Exactly. And initially, this case went through the lower courts, both the District Court and the 10th Circuit Court of Appeals. Both of those courts, they sided with McCarthy and Holthus. They said the law firm didn't fit the definition of a debt collector under the FDCPA, at least in this particular scenario.
So that's how it ended up all the way to the Supreme Court, right?
Yeah.
Because they had conflicting rulings.
Well, yeah, the Supreme Court gets involved when there's this kind of disagreement between lower courts or when there's a really significant legal question at stake. And this case had both. It was a bit of a legal puzzle about how to apply the FDCPA to the whole world of foreclosures.
Okay, so that brings us to the Supreme Court's decision.
Yeah.
And you mentioned earlier that this all boiled down to how the FDCPA defines debt collector.
Absolutely. That definition, you can find it in section 1692A of the FDCPA, and it's actually got two parts, which makes it even trickier. Understanding both parts is crucial here.
Okay, let's break it down. What's the first part of the definition?
The first part, it's kind of the more general definition. It basically says a debt collector is anyone whose main business, their principal purpose, is collecting debts. Or, folks who regularly collect or try to collect debts owed to someone else.
So the classic debt collection agencies, right?
Exactly. Think of the stereotypical, the ones you see in movies, hounding people over the phone.
Right. But then there's this second part, which I think is where things got really interesting in this case.
Yeah, the second part of the definition is a bit more specific. It says a debt collector also includes anyone whose principal purpose is enforcing security interests.
Okay, back up a sec. What exactly do we mean by security interests?
Good question. So a security interest, it's basically a legal claim on a piece of property. Think of a mortgage on a house or a loan on a car. The lender, they have a right to take that property if the borrower doesn't pay up.
Okay, so this second part of the definition seems to be directly targeting those kinds of situations, foreclosures and repossessions, right?
You think so, right? But there's a catch. And this is where it gets really important. This second part of the definition, it only applies when we're talking about that very specific section we mentioned earlier, 1692(6). You know, the one about not taking possession of property if you don't have the right to.
So basically the second part is saying, yeah, these folks might be debt collectors in this very limited circumstance when they're trying to seize property.
Right. And the Supreme Court, they really zeroed in on this whole structure of the definition. They specifically focused on the word also in that second part.
Interesting. Why that one word?
Because the court basically said, if everyone who enforces security interests was already covered by that first broader definition of debt collector, then why even bother with this second more specific definition? Like, it would be redundant, right? If they're already included, you don't need to say it again.
So the word also, that kind of threw a wrench in things.
It did. The court saw it as evidence that Congress was trying to separate these two things. They were saying, look, the process of enforcing a security interest, like with a non-judicial foreclosure, it's different from just the general act of collecting a debt.
It's almost like Congress was creating a kind of special category, right?
Yeah, and the court thought this was probably done to avoid messing up the whole system of state laws that already govern foreclosures. You know, you've got all these state-level rules and consumer protections in place, and Congress didn't want the FDCPA to just bulldoze over all of that.
Makes sense. You don't want federal law and state law constantly bumping heads, right?
Exactly. You need clarity, not chaos.
Okay, so this whole logic of also in separate categories, that seems to be the heart of the Supreme Court's reasoning. But I do want to bring up some of the arguments that Obduskey's side made, because they raised some valid points, right?
Oh, absolutely. They weren't just throwing darts at a board. Their arguments were pretty smart, and they really pushed the court to think this through carefully.
Like one of their arguments focused on the whole idea that maybe this second part of the definition, that more limited one, wasn't actually pointless or redundant. They suggested it was meant to cover a specific group, repo men. You know, the people who repossess cars and stuff.
Yeah, that was an interesting angle. Their argument was basically, hey, these repo guys, they might not always be seen as your typical debt collectors. So this second part of the definition was meant to make sure they were covered by the FDCPA, at least when it came to actually taking possession of the property.
It's a good point, right? Like repossession, it's a very specific action.
Right. And the court, they took this argument seriously, but ultimately they weren't convinced.
Why not? What was their counter argument?
Well, they looked at the language of the definition itself. They pointed out that it uses the phrase enforcement of security interests. That's pretty broad, right? It doesn't just say repossessing cars.
Yeah, it covers a wider range of actions.
Exactly. And if Congress had meant only repo men, they could have used way more specific language. Plus, the court also made the point that even repossession, in a way, it's a form of debt collection. It's just a more, indirect way.
Because the goal is still to get back the money that's owed, right?
Exactly. They're recovering assets to cover the debt. And the court even suggested that, if someone's threatening to foreclose on a property when they don't actually have the legal right to do so, that could potentially be considered a violation under that section 1692(6). They saw it as a kind of non-judicial action to take possession.
So even in that context, there are limits on what these companies can do.
Absolutely. The law is trying to prevent those kinds of shady practices.
Obduskey's team also pointed to a different part of the FDCPA, section 1692IA, to support their argument. This section deals with where a debt collector can file a lawsuit to enforce an interest in real property. They were essentially saying this only makes sense if companies doing foreclosures are considered full-fledged debt collectors. Otherwise, what's the point of this section?
That was another clever point they raised. They were trying to show that the FDCPA itself seemed to treat these foreclosure actions as falling under the umbrella of debt collection.
But what did the court have to say about that?
Well, the court, They clarified that this particular section, 1692 IA, it's not actually defining who a debt collector is. It's really just setting rules for where a lawsuit can be filed, and it only applies when the company or person bringing the lawsuit already qualifies as a debt collector for some other reason.
So it's like a procedural rule, not a definitional one.
Exactly. And in Obduskey's case, the only action they were pointing to was the nonjudicial foreclosure itself. So the section about where lawsuits can be filed, it didn't really change the fundamental question of whether McCarthy and Holthus should be considered a debt collector in the first place.
And their final argument, the one about the notices. Obduskey's side argued that just by sending those foreclosure notices, McCarthy and Holthus was going beyond simply enforcing a security interest. Those notices, they argued, were clearly attempts to pressure Obduskey into paying the debt.
Yeah, they were basically saying that the act of communication, of sending those notices, that itself could be seen as debt collection activity.
It's a compelling argument because those notices, they can be pretty intimidating.
No doubt about it. They carry a lot of weight.
Yeah.
And the court acknowledged that these notices are serious business. But they also emphasize that, at least in Colorado, under state law, sending these specific types of notices is a required step in the non-judicial foreclosure process.
So the court was saying, these notices, they're not just some optional tactic. They're part of the legal procedure itself.
Exactly. And because the FDCPA specifically carves out this exception for the enforcement of security interests, except for that one provision about taking possession without the right to, the court said this exception has to also cover the necessary legal steps that go along with that enforcement.
So as long as they're following state law to the letter, it's all good.
Well, all good might be a bit strong. I think that the court recognized that there's still potential for abuse within this system. That's why they specifically highlighted that states have their own laws to regulate these processes, and Congress can always step in and change the FDCPA if they see a need to.
So there's still room for adjustment down the road if issues arise.
Absolutely. This isn't necessarily the final word on the matter.
Okay, so that covers the main points of the majority opinion. But we also had Justice Sotomayor. She wrote a concurring opinion, right? Meaning she agreed with the outcome, but maybe had some different thoughts on how they got there.
That's right. She agreed with the court's decision, but she made it clear that it was a close call for her. And she raised some really interesting points.
What were some of her concerns?
Well, she pointed out that that first definition of debt collector in the FDCPA, it's written really broadly. You know, anyone whose principal purpose is collecting debts.
Right, we talked about that.
And she was saying if you interpret that first part super broadly, it's not hard to argue that foreclosure is a way to collect a debt, right? You're trying to recover the money owed. So she was wrestling with that a bit.
She was basically saying if the first part already covers it, then what's the point of the second part?
Exactly. That was her concern. If you interpret the first definition that way, the second one about enforcing security interests, it seems kind of pointless, almost like it's just there for decoration.
Like, why bother having it at all?
Right. She did acknowledge the argument that maybe the second part was meant to cover those folks who enforce security interests, but who don't do a lot of direct communication with debtors, like some repossessors.
Yeah, that was one of the arguments Obduskey's side made.
Right. But Justice Sotomayor, she still felt like it was a bit of a clunky fit. It didn't completely resolve that feeling of redundancy in the law. Like, why have the second part if the first part already does the job?
Okay, so she was grappling with that.
Yeah.
But what was her main takeaway? What did she really want to emphasize?
She really wanted to emphasize that the court's decision was very specific. She said it's only about actions that are specifically required by state law to actually carry out that security interest enforcement.
So they're saying as long as you're following the state's rules to the letter, you're probably okay.
Right. But she made it very clear that this doesn't mean anyone can just go around using abusive tactics. She even gave the example of, let's say, someone's threatening a homeowner with foreclosure when they don't really intend to actually go through with it, just to try and scare them into paying. She suggested that that kind of behavior, even if it's technically within the realm of security interest enforcement, that might be viewed differently by the courts.
So it's like a warning shot, right? Saying, don't get any funny ideas, folks.
Yeah, she was basically saying, don't try to exploit this ruling. The court's decision was based on the specifics of this case, where the actions were very clearly tied to state-mandated procedures.
Okay, so we've got the majority opinion, the concurring opinion, a lot to digest here. But before we wrap up, I think it's always interesting to put on our 10th chair hats for a minute, you know? to step back from the legal nitty-gritty and look at the bigger picture.
Yeah, the 10th chair perspective. That's where we get to play Supreme Court justice for a day.
Exactly. So from your 10th chair perspective, what's your main takeaway from this case? What stands out to you?
You know, for me, it really feels like the court was walking a tightrope here. They were trying to balance two things. On the one hand, you've got the whole purpose of the FDCPA, which is to protect consumers from truly abusive and harassing debt collection practices.
Right. That's the core of the law.
But on the other hand, you've got these state-level procedures for foreclosures, especially non-judicial foreclosures, that have been in place for a long time. They're complex systems with their own set of rules and safeguards, and the court didn't want to disrupt that whole system unnecessarily.
It's like they were trying to avoid throwing a wrench into a delicate machine.
Exactly. Trying to force the very specific procedures of non-judicial foreclosure into the broader framework of general debt collection, that could have had some really unintended consequences. It could have created confusion and uncertainty in how these state systems operate.
And potentially made things even harder for homeowners who are already in a tough spot.
Exactly. I think the way Congress crafted the FDCPA with that two-part definition, it suggests that they recognize that enforcing a security interest, like with a mortgage, it's got its own unique characteristics. It's not exactly the same as, say, chasing down someone over unpaid credit card bills. And the court's interpretation, it seems to respect that initial intent from Congress that these situations should be treated somewhat differently.
But the key here, as both the court and Justice Sotomayor pointed out, is that this ruling is really dependent on the actions being taken, being truly about enforcing that security interest, and being specifically required by the state's laws.
Yeah, that's the critical line. As soon as you step outside of those legally mandated procedures, things could get a lot murkier.
And potentially open you up to FDCPA violations.
Exactly. So for our listeners out there, if you're ever facing a situation like this, it's crucial to understand both the federal laws like the FDCPA and your own state's laws regarding foreclosures. They're both important pieces of the puzzle.
Don't go it alone, right? Get some legal advice.
Absolutely. This case really highlights how complex these issues can be. You need someone on your side who understands the intricacies of the law.
So to wrap things up, this deep dive into Obduskey v. McCarthy and Holthus LLP, it's been a journey. But hopefully it's given our listeners a better grasp on how the Supreme Court has interpreted the FDCPA in the world of non-judicial foreclosures.
And while the main ruling does provide some clarity, we also have Justice Sotomayor's concurrence, reminding us that the application of this decision will likely continue to be scrutinized, especially in situations where there are questions about whether actions might cross the line into abusive practices, even if they're technically within the realm of enforcing a security interest. It's going to be interesting to see how future cases apply these principles.
Yeah, the legal world never sleeps. There's always another case around the corner.
That's for sure.
Well, on that note, we've reached the end of our deep dive. We hope this discussion has been informative and, dare I say, maybe even a little bit entertaining. If you're left with any burning questions, we encourage you to dig a little deeper. Check out the FDCPA itself. Familiarize yourself with the foreclosure laws in your own state. Knowledge is power, as they say.
Couldn't agree more.
So until next time, keep exploring, keep learning, and we'll catch you on the next deep dive.
See you then.